Global from capital gains tax in 2018 Flipkart deal. The Supreme Court ruling has stated that the US-based firm Tiger Global and its related entities are liable to pay tax on $1.6 billion exit from Flipkart, and they aren't exempt from the taxes under India-Mauritius DTAA. Let's go across to Pranav Saitha from Ernst & Young, what he had to say about the judgment and how will he read with immense interest by shareholders and globally and not just in India. What does this ruling really mean for investors and taxpayers? We caught up with Siddharth Pai, founding partner at 314 Capital. Let's listen into what he had to say as well.
A vast number of investors no longer look at the tax advantage or the tax arbitrage as one of the factors to consider investing into India. In fact, from 2019 also, most of the larger fund houses have either pivoted away from Mauritius to go directly to go to Singapore, to end up actually coming to India directly, to go to GIFT IFSC, which also came out into 2019 over there for that matter, or they're looking at other pooling jurisdictions like Dubai, etc., to end up actually investing into the country. Now, the biggest risk for the industry as of now is the uncertainty of whether the tax department is going to go back and start reopening previous assessments and start actually asking questions about the actual substance of the and the presence of the manager in Mauritius when the decision to make the investment or to divest the securities ends up actually happening. In fact, it's fair to say that a large number of investors who have structures in Mauritius, large number of them do end up actually facing a immense amount of tax litigation. So the joke among the industry is that investing to Mauritius is a lot like the song Hotel California. It's very easy to check in, but it's impossible to end up checking out and leaving. So that is something that's actually been part and parcel of it. Now, this agreement is looking into the future is not as much of an impact after all, because the industry has already seen the cracks in the Mauritius structure and they've already ended up pivoting. But the uncertainty of reopening older cases or actually looking at previous exits and all is something that's casting a massive ball across the entire industry itself.
All right, so that's about the expert take on the same, but let's understand this news flow in detail. My colleague Sumita joins in with more details.
Absolutely. So this ruling essentially is a big setback to Tiger Global. The Supreme Court in a landmark case today ruled that Tiger Global's $1.6 billion stake sale to Flipkart to Walmart in 2018 is subject to taxes. In fact, Indian tax authorities challenged an earlier case on the matter as well, which was in favor of Tiger Global, but this one has completely changed gears. In fact, this case is centered on whether taxes should apply to Tiger Global's sale of its Flipkart stake to Walmart in 2018. And this sale, that's valued at about $1.6 billion. It formed part of Walmart's $16 billion of acquisition of the Indian e-commerce firm that year. The Supreme Court then said that the $1.6 billion stake sale in Flipkart at that time of the Walmart-Flipkart acquisition deal is subject to tax. Now, this hands over a win to New Delhi and, of course, the tax authorities here in this landmark ruling. This is related to the use of international tax treaties by companies. So this is going to be having a major impact on investor community, overall investor community as well. And this was keenly watched by foreign investors and the legal disputes that are related to how the US investment firm essentially used the India-Mauritius tax treaty to claim tax exemptions and New Delhi's fierce objections to it.
All right, with that, it's time for us to slip into a short break. Don't go anywhere for the break. We'll get you more updates on the other side. Stay tuned.